We're going to talk about agency in this area, agency law. There are some factors that are important in determining whether you have a agent, principal, or an independent contractor. These are the factors that are used. How much control can an employer exercise over the details of the work? So if you have an employer with an employee, there's a lot of control. A principal with a agent, there's a lot of control. With the independent contractor, not so much. Number two, is the worker engaged in an occupation or business distinct from the employer? So if the worker has a business that is outside of the employer, it probably is going to be an independent contractor. Is the work done under the supervision of a or direction of the employer or the principal? If that answer is yes, it's probably an agent or an employee. If it's not done under the supervision, it's more likely to be an independent contractor. You weigh all of these factors. Does the employer supply the tools? Employees and agents are usually supplied tools. Other questions: for how long is the individual employed? What is the method of employment? So if it's a long time for being working for someone, that's probably an employee or an agent as opposed to an independent contractor. Independent contractor may be a certain job or for a certain period of time, and usually a shorter period of time, and compensation will be a flat amount as opposed to a salary or a wage. Also, what degree of skill is required? More skill, it may be an independent contractor. With the agency relationship, if you have a disclosed principal, which means at the time that the agent negotiates the contract with the third person knew both who the principal was and that there was a principal, then the only parties to the contract will be the principal and the third person. The agent will not be a party to the contract, so the agent cannot be sued. If you have an agent that is hired to do a specific job, like a real estate agent, that would be a special agent. If you have an agent that, or a person who can negotiate contracts as an agent, but a agent that can do or negotiate contracts within the context of a business, that will be a general agent, like hiring a manager. If you have a person who has a power of attorney, written power of attorney, and can negotiate all lawful contracts on behalf of another party, that's called a universal agent. How the agency relationship is created. If it is expressly given by the principal to the agent, it's express authorization or express agreement. If it is either the person who's acting as an agent went outside of the authority that they have, or they didn't have any authority, but the principal later finds out about it and the principal agrees to the unauthorized acts by their conduct, then the agency relationship will be created by ratification. For an agency by ratification, the intention to ratify must be expressed in words or be found in conduct. Also, the following must exist. The agent must have purported to act on behalf of or as an agent of the identified principal. The principal must be capable of authorizing the act both at the time the act was done and also when it was ratified. The principal must have full knowledge of all material facts. The effect of ratification: when an unauthorized act is ratified, the effect is the same as though the act had been originally ratified. This means that ordinarily the principal and the third party are bound by the contract made by the agent, even if the agency relationship was created by ratification. This is an example. How was the agency relationship formed? Arnstein asked Grace, a gardener, to contract with others for the care of his lawn on a regular basis, and Grace agrees to act as an agent. This agency relationship was expressly given by the principal, so it was created by an express authorization or express agency relationship. How is this formed? Jesse is not an agent for Bob. Nevertheless, Jesse purchases a couch on Bob's behalf from Furniture Mart. When Bob discovers this, he scolds Jesse. Thereafter, Bob attempts for 2 weeks to sell the couch in his store. After being unable to sell the couch, Bob calls Furniture Mart and tells them that Jesse is not an agent. Well, guess what? By trying to sell the couch for the 2 weeks, Bob has ratified or create an appearance of authority in the mind of Furniture Mart as the third person. And so the agency relationship has actually been created by ratification. So this is an example of ratification. So you have to look for an unauthorized act by the agent, and then the principal's conduct or words actually accept or agree to that unauthorized act. Determine the outcome. Jesse is an agent for Bob, and he was hired to purchase furniture. Bob has informed Jesse that he cannot purchase furniture that costs more than $1,000. Despite these instructions, Jesse purchased a couch as an agent for Bob with Furniture Mart that cost $1,500. When Bob discovers this, he scolds Jesse. Thereafter, Bob attempts for 2 weeks to sell the couch in his store. After being unable to sell the couch, Bob calls Furniture Mart and tells them that Jesse did not have the authority to purchase the couch. Well, guess what? By trying to sell the couch for 2 weeks, they had created an appearance of authority. So even though in this case, Jesse acted outside of the scope of his authority by buying furniture that was more than what he was given the authority to purchase, the unauthorized act was ratified. So this is another example of ratification by Bob attempting to sell the couch. Bob ratified Jesse's unauthorized action and will not be able to return the furniture. The agent's authority. The types of authority of the agent. The agent can have express authority. This is where the principal tells the agent to perform a specific act. So if the principal tells the agent to buy new furniture and sell specified used furniture, then the agent has the authority to do this. The agent can also have incidental authority. Incidental authority is any act reasonably necessary to perform the act expressly authorized. So if the agent was told to buy new furniture but not given cash, the agent has the authority to buy the furniture on credit because it's incidental to what is needed to be done to meet the agent's express authority, which is to buy new furniture. There's also customary authority, an act that according to custom of similar businesses in the community usually accompanies the act performed under the express authority. So if this agent was told to sell used furniture, the selling of used furniture means that the agent is going to collect money. It's customary for people when they collect money to give receipts. So this agent has customary authority to give receipts to those people who actually purchased the used furniture, even if the principal did not say otherwise. The apparent authority. The principal was present when the party purchased furniture from the agent and did not stop the unauthorized act. So notice that one of the instructions was here, let's say that there were two different stores. Let's say that, and this is not on this example, that the principal told the agent that they could not sell furniture in another store. What would happen if the principal was present when the agent sold furniture in the store that the agent was forbidden to sell furniture from? In that case, the principal, if they saw this unauthorized act and didn't say anything to the third person who was buying this furniture in this store that the agent didn't have the authority to sell, the principal, by not doing anything, has ratified or agreed to the unauthorized act. So that would be apparent authority. As long as the agent has some type of authority, that's enough to bind the principal. Terminating the agency relationship, it could be by the act of the parties. They decide, the agent decides he or she does not want to be an agent anymore, or the principal fires the agent. It can also be by operation of law. Ordinarily, the death of either the principal or the agent will terminate or end the agency relationship. If the principal or the agent become bankrupt, that would end the agency relationship. Or if it's impossible to perform the contract, like if the subject matter of the contract has been destroyed. Let's say a real estate agent was supposed to sell a house, the house was destroyed in a fire. That would terminate the agency relationship because that's the subject matter of the agency relationship. When an agency has been terminated by the act of the principal, it's the principal's duty to inform any third persons. If terminated by the agent, the principal only has to inform those third parties who've had prior dealings with the agency relationship or the agency.